Good afternoon, everyone. Thank you so much for joining us. I'm Joan Woodward, and I'm honored to lead the Travelers Institute, the public policy division and educational arm of Travelers. Welcome to Wednesdays with Woodward, a webinar series where we convene industry experts about conversations for today's biggest challenges. We're so glad you're here. Before we get started, I'd like to share our disclaimer about today's program. I'd also like to thank our webinar partners today, the Connecticut Business and Industry Association, the Insurance Association of Connecticut, TrustedChoice.com, Metro Hartford Alliance, and the National Association of Professional Insurance Agents. So as everyone knows, today's labor market and workplace laws are rapidly evolving and increasingly complex. From hiring to firing to promotions and workplace culture, businesses face daily decisions that affect their employees and could lead to claims of wrongful employment practices for even the best intentioned employers. Economic conditions, societal trends, and the ever-evolving legal environment have led to employment practice claims increasing over the years. Employment-related claims impact organizations of every size and in every industry and can disrupt businesses, hurt employee morale for sure, damage reputations, and cost businesses financially before even going to court. With over 80,000 U.S. workplace discrimination charges filed in 2023, understanding employment practices liability, or EPL, is crucial for employers of all sizes. Today, we're going to take a deep dive and look at current trends in employment-related insurance claims, recent legal changes that you need to know about, and strategies that employers can use to reduce employment liability risk. Joining me for that discussion today are two experts in employment practices liability. Sarah Soukas is a partner with the law firm of Jackson Lewis, a national law firm focused on employment and labor law. Sarah's practice is focused on employment litigation. She defends employers in a variety of industries, including healthcare, higher education, restaurants, nonprofits, manufacturing, against claims of discrimination, harassment, retaliation, wage and hour violations, and state and federal FMLA violations. That's a mouthful. That's a lot, Sarah. She also assists employers in providing preventative counseling, preparing employee handbooks and policies and procedures, and advising on personnel matters. So welcome, Sarah. We're really thrilled you're joining us today. Next up, we have Chris Williams. He's an Assistant Vice President for Executive Liability and Employment Practices Liability Product Manager for Travelers. In this role, he's responsible for employment practices, underwriting strategy, marketing, training, and consultation on complex EPL accounts. Chris has been with Travelers for almost 25 years. So he's going to start us off with a level set on the EPL landscape, what we're seeing today, followed by then Sarah, who will share with us some top takeaways from the Jackson Lewis mid-year legal update that they just published. So Chris, welcome. Sarah, welcome. And the virtual floor is yours. Take it away.
Thanks, Joan, for having me. I really appreciate it. So I thought I'd just start off talking a little bit about what EPL insurance actually is. So EPL is designed to cover insurance or to cover employers who see claims brought by their employees, their former employees, or applicants for things like wrongful termination, discrimination, sexual harassment, and retaliation. And what the policy generally covers is defense expenses, so the cost of a lawyer to respond to the lawsuit or the EEOC charge or the demand that comes in, the damages themselves, which would generally in most EPL cases include things such as lost wages, emotional distress damages, or the claimant may have damages for damage to their reputation. Under most employment statutes, the claimant's also entitled to their attorney's fees if they prevail in the claim. Most employees are at-will employees, and what that basically means is that the employee or the employer can terminate the employment relationship at any time. But there are exceptions to that about when the employer can actually terminate that relationship. So for example, Title VII of the Civil Rights Act prohibits an employer from discriminating against an employee on the basis of their national origin, color, race, religion, and sex. So an employer could not terminate an employee on that basis. Say the statute goes a little broader than that, though, because it doesn't just apply to hirings and firings and terminations, but it also applies to promotion, pay, benefits, and the working conditions overall. And it also prohibits harassment based on those protected characteristics. If an employee wants to pursue a claim under Title VII, you don't just go out and file a lawsuit. One of the prerequisites is the employee has to file a charge with the Equal Employment Opportunity Commission. One of the things the EEOC does is when they settle cases, they generally publish those results. So I thought it might just be helpful for the audience to give you a couple examples of some of the claims they published. And these aren't hard to find if you go on the EEOC website and you look in their newsroom, you can see all the settlements they've entered into. So I'll give you a couple examples. Was a restaurant, a franchise restaurant, the owner instructed the general manager not to hire minority workers, and he used derogatory language about minority workers that were working in the establishment. As a result, the EEOC brought a claim. It's almost a little shocking to me that these things still happen in today's environment. You'd think we sort of would have been past that, but we certainly do continue to see those claims, unfortunately. Second example, a construction company. They were playing music on the shop floor that contained sexually suggestive nuances and derogatory language about women. One of the female employees complained about that language, and management didn't do anything. So two problems with that. One, the music was allowed to be played in the first place. And two, once management was aware of it, they failed to take any action to stop that. The third example was by a chef against a restaurant. He was hired and he did not work Sundays for religious reasons. A new manager came into the organization and instructed the chef that he did in fact have to work on Sundays. See, this is fairly common where you have a new manager comes in maybe without adequate training and sort of tries to put their footprint on the organization. And in this case, the employee was entitled to an accommodation and they failed to grant it, and they faced an EEOC claim. So there's a couple other examples of statutes that provide protection to employees and applicants. So the Pregnancy Discrimination Act prohibits discrimination on the basis of pregnancy and childbirth and related medical conditions. The Americans with Disabilities Act prohibits discrimination on the basis of somebody's disability, and it requires employees to provide accommodations for those disabilities unless it causes an undue hardship. So you've probably read about things like that, Joan, where it's things like maybe putting in a wheelchair ramps, giving an employee extra time to complete a task, maybe providing technology that's accessible, or things of that nature. It could also be allowing the employee to work from home for a certain period of time. Age Discrimination and Employment Act, that prohibits discrimination against those over 40 years old. So we see a number of those claims are sort of older workers. You may remember people were going, okay, boomer, when older people said things, calling somebody grandma or grandpa in the workplace, asking people when they're going to retire. In the interest of time, I wasn't going to go through all of these, but that's just some high-level statutes that apply. All of those statutes also prohibit retaliation. So if an employee complains about retaliation and the employer takes an adverse action, it doesn't have to be a termination. It could simply be sort of relegating them to the basement like the Office Space movie, giving less desirable work assignments or things of that nature. That constitutes retaliation. Surprisingly, in over half the EEOC charges that are filed, they include allegations of retaliation. So we see claims where a company will get an EEOC charge, and the first thing the company does is they fire the individual that brought the charge. If there's any takeaway from this discussion today, that is a big no-no from an EPL perspective. Broadly speaking, I'd say there's really three issues that give rise to employment claims overall. One, the employer simply does not follow the law. Law can be complicated, and employers may not have the resources to stay up to date on what their obligations are under the law. say the second thing is rogue employees, and that sort of may connote sort of a Pirates of the Caribbean theme, which is not my intent. It's really just employees acting in the workplace that are acting sort of outside what would be considered norms for civilized society. And those employees can create real significant exposure for the employer overall. And the third one is really just factual disputes overall between employees and employers. An employer may decide that the employee is not qualified to do their job and make a decision to terminate the employee based on their performance to date. And the employee could view that as discriminatory. And that's a factual issue about what really drives that termination. Sometimes employers don't follow their own obligations under the law, what their own policies and procedures might require. We see a number of claims, for example, where the employer will say, well, they were a terrible employee that didn't do A, B, C, and D. And then you go back to look at their performance reviews and they're stellar for the last 5 years. So that creates a factual dispute. And finally, I'd say a number of employers may decide they're trying to be kind and they lay off an employee rather than firing them, saying we're doing this because of economic constraints. And then 2 months later, they hire a replacement of a younger worker or somebody that's not in a protected class. And that can give rise to sort of a factual dispute and create exposure for the employer. So that's my brief view of the world overall from an EPL perspective. And let me turn it over to Sarah for her mid-year legal review on the state of EPL. Thank you.
Great. Thanks so much, Chris and Joan, for having me here today. I have a lot to talk about, so we're going to jump right in. I want to start with the Supreme Court and a recent decision kind of reining in federal agencies. So essentially, we're going to call it the demise of the Chevron deference. I'm going to try to make it not too legalese. Basically, there had been this long-standing decision from a court case back in 1984 that we call the Chevron deference. And essentially, that court case for over 40 years gave federal agencies deference to their rulemaking. So when agencies implemented rules interpreting statutes like, Title VII or the FLSA, the courts gave deference to the agencies in their own interpretation. And so when those rules were challenged, courts said, no, we've got to give some deference to the agencies on their own interpretation, which made it really hard for challenges to those rules to be successful. And so this year we saw the Supreme Court overturn that Chevron deference and rejected that doctrine. And it's a pretty landmark decision. You're going to see it already has been. It will continue to challenge rules like the Pregnant Work Nurse Fairness Act, which we're going to talk about today. The Department of Labor's minimum salary rule that's affecting a lot of employers today, and a lot more. Some of the key takeaways moving along to as a result of this Supreme Court decision, it's, like we said, a lot is in play. The decisions aren't striking any employment regulations yet. There have been challenges to some of these key laws, but for the most part, a lot are still in play. But we're going to see a lot of legal challenges to these agencies. And there's a lot of uncertainty for employers as a result, right? When agencies used to issue rules and regulations, we kind of thought, well, they have a lot of deference. We're going to assume they're going to be enforceable and in play. And with that gone, we're going to see a lot of legal challenges and a lot of uncertainty. So employers are kind of watching the dust settle, watching a lot of these litigations around all of these agency rules that affect a lot of employers' day-to-day operations. It's a really big thing we're going to continue to watch. Moving along, one of the biggest rules and regulations that's affecting a lot of employers right now is the Pregnant Work Nurse Fairness Act rule. And essentially, this was a rule that was adopted to kind of fill gaps with that Title VII and ADA Chris was talking about, those protections that are afforded. And really, essentially, the goal of the Pregnant Workers Fairness Act, the PWFA, was to make sure that if you're pregnant, childbirth, or related medical conditions, that employers are providing opportunities for those individuals to continue to work during their pregnancy or related conditions in a safe and a secure environment. And so It applies to 15 employees, and it does a lot of things. Basically, we've kind of put it in a nutshell, but there's a lot more to it. The EEOC, in implementing these regulations, doubled down and really broadened the definition of pregnancy, childbirth, and related medical conditions. That's that acronym PCRMC. The EEOC has rejected comments suggesting that this definition be more narrowly defined. So we're seeing a real shift in how broad the protections are for people who may fall under this PCRMC definition. We're seeing a new definition of temporary. So what does that mean for employers? So if an employee is pregnant, the final rules presume that the employee could continue to perform those essential functions in the near future because they could perform the essential functions within the 40 weeks of their pregnancy. 40 weeks still does not apply to the period of recovery of childbirth, but it really broadens the nature of temporary restrictions, and it means employers are going to have to review how they're treating, pregnant employees who may need accommodations and reevaluating it in an entirely different way. Now, family members are not entitled to accommodations. This obligation to provide accommodations to pregnant employees applies only to the qualifying individual. But essentially, if a pregnant employee is asking for an accommodation, it's easier to ask for one. And there's additional language in the regulations expanding an employer's obligation to consider those obligations about potential accommodation. That may include working at home, nursing, lactation while at work, or nursing while at work. And some of these have been in place. There's also state laws that often provide greater protections than what's always been in place in federal law. But the big takeaway for employers is you got to change your default settings. If you have an accommodation request related to pregnancy and childbearing, it's not the ADA accommodation standard. And so this is where a lot of preventative counseling can come into play. You really have to evaluate the accommodation process in a whole new light. We've listed some of the key takeaways. If I were an employer, what would I be doing? I would certainly be seeking legal advice if I have a pregnant employee. This is a new landscape, and it's not how we've always employed the accommodation process before. There are some requisite poster requirements. Take a look at your policies. That's a really important step. And of course, training your HR team, frontline supervisors, so they know what to say when an employee approaches them about a potentially needing an accommodation to deal with a pregnancy. Another big topic is always is in the EPL landscape, discrimination and harassment. But I want to talk a little bit about one of the key developments that we've seen so far this year, which is another agency, right, implementing regulations that affect the workplace. Here, we're going to talk a little bit about the EEOC enforcement guidance on harassment. So the EEOC, right, is the federal agency that's charged with investigating and implementing federal anti-discrimination statutes. And the EEOC came out with this enforcement guidance. And there's a lot of provisions. I've put some of these on these slides for you. Some things I wanted to highlight for you in this updated guidance is, certainly we're seeing a focus of the EEOC having sex-based harassment, to clarify that includes conduct based on an individual's sexual orientation and gender identity, including how that identity is expressed. So that could be, for example, this is all according to the EEOC guidance, I want to be clear, but that could include perhaps outing a person's sexual orientation or gender identity. Repeated or intentional misgendering is also specifically included. Dead naming, right? Using a name used by a person prior to a gender transition. And denying a person access to bathrooms. So we're seeing the EEOC really focused on some of those gender identity issues in a more explicit fashion through this EEOC enforcement guidance that they expect employers to comply with. Couple of additional key points are the new guidance really does highlight examples of the gender-based assumptions, family roles, leadership abilities, Even well-intentioned stereotypes per the EEOC guidance, such as suggesting to an older employee that they should retire to enjoy their golden years, right? That constitutes prohibited conduct. And these are all things that people are not intentionally discriminating, but may in the workplace say something that the EEOC in this guidance is making it very clear that in their opinion is not appropriate, and they're going to be holding employers accountable. Certainly, even facially neutral conduct can also be related to facially discriminatory conduct per the EEOC guidance. And so employers should really be taking a look at this enforcement guidance to make sure that they're familiar with these standards across the board. It's a really big formal document that's come out that we recommend everybody take a look at. Moving on to our next topic is taking a look at some significant enacted legislation. There are a lot more topics that we could include, but given I didn't want to take the whole topic today on some of these, I did want to highlight a few statutes. So in addition to all the federal laws that Chris outlined for us at the beginning as to the intersection that affects EPL policies, there are a lot of state laws that also come into play. I've highlighted a couple of new developments. Certainly, if you're in California, PAGA is not a new name for you. Essentially, PAGA is the Private Attorneys General's Act. It is an act in California that allows aggrieved employees to bring a lawsuit, not just on their own behalf, but on behalf of other employees and even on behalf of the state of California for aggrieved labor law claimed violations. It's a huge issue in the EPL space for our California clients. And essentially, this new law came about as a result of several months of negotiations in the state of California for PAGA reform. It does a couple of key things that I do want to touch upon. One is it does provide caps on penalties on employers who quickly take action to address alleged labor law violations after they get a PAGA notice, which is part of the procedural process in bringing a claim is the initial PAGA notice. So employers who act quickly to address those are going to be benefiting from the caps imposed. Also, employers who proactively work and demonstrate that they've taken steps to comply with the labor law issues before they get a PAGA notice may be able to avail themselves of some of those monetary caps. It's pretty huge for PAGA actions. Unfortunately, PAGA also increased the higher penalties on employers who act maliciously, fraudulently, or oppressively in violating labor laws, meaning so on one hand, it limited some of the penalties, but on the other hand, it also increased the penalties as well. Another key component of the PAGA reform that I think is really important to highlight in this EPL space is that there's going to be more penalty money going directly to the employees. So, right, employees can bring this claim on behalf of the state of Connecticut, and under the former PAGA, they could recover 25%. Now there is a 35% benefit of recovery to the employee who brings it. So what does that mean, right? It could mean there's more incentive to employees to come forward and bring PAGA actions on behalf of the state of Connecticut, state of California, or other employees. And so I think that's going to be a real impact to PAGA litigation, which if you're in California, you know this word. Another major law that came into effect I want to briefly highlight is Colorado Job Application Fairness Act. It's really on trend with what we're seeing in a lot of states, prohibiting employers asking about employees' age, dates of birth, date of attendance, right, on graduation from educational institutions. This is kind of the low-hanging fruit because it's not what we do when we're interviewing. We always ask, when did you graduate? So that's a trend we're seeing across the board. Moving along I want to touch upon a few other statutes that are important. We're seeing, again, not new, but increasing paid leave, paid sick leave. It's been a trend for the last 10 years in the EPL space. We're going to continue to see more protections for paid sick leave, paid FMLA, and Illinois is no exception. Moving along to Louisiana, we've got a couple of more statutes in Louisiana. Again, Really, this is around this trend about arbitration agreements that essentially avoid employees going to court and instead forcing claims to be brought in arbitration, consistent with trends we're seeing when it concerns allegations of sexual harassment, a continuing saying, hey, you cannot force somebody to arbitrate. They have that right to go to court. And then another final slide that I want to touch upon briefly are some developments in Maryland and New York. We put all these details up on the slides, but Maryland, I want to highlight it because it alters a requirement that an employer disclose certain wage information. We're seeing a lot of legislation around when can employees talk about their wages, when can employers prohibit employees talking about their wage information. And then the New York bill is, again, providing 30 minutes of paid break time. Again, we're seeing a lot of increased legislation in these areas. And so it's a mouthful, but I wanted to get some of these key states and developments into your line of sight. It's all about issue spotting. With that, I'm going to turn it back to Joan.
All right, Sarah, thank you so much. And Chris was really terrific presentations to kind of set the stage for us. And there's a lot going on with this topic. So Sarah, I want you to take us kind of behind the scenes. When an employer comes to you with an issue in general, what's that first call like? And are there a lot of cases that something could have been foreseen and maybe prevented that you see coming towards you?
I am a big believer, Joan, in a 30-minute preventative call can go a long way to avoid litigation or at least minimizing exposure, right, in litigation. So when a client calls, they're nervous, right? It's their business. It is often huge. And to your point, labor is a huge component of operating a business. Most employers, in my experience, want to do the right thing. They're not necessarily, though, aware of all these legal complexities. So my job in an initial client call is to really help issue spot, walk through what the issues and help them flag, hey, did you think about this? Maybe we should be, doing X, Y, and Z. And that's, it's really complicated and employers get overwhelmed. So that's usually my initial call. I would much rather spend 30 minutes on a call with a client than 2 years of litigating with them.
Sure, certainly. And how about the mom and pop shops, right? Some very small businesses that don't have a whole legal department at their side. So just understanding what these risks are out there with a early call. Okay, thank you for that. Chris, let's talk about how much it can actually cost an organization that gets hit with an employment practices suit. And you're looking through all the claim data that we see, thousands of them, right, each year. What's the average cost of this?
So there's, to Sarah's point, there's a non-monetary cost, right? For the audience, maybe think about a stressful, anxiety-producing situation you've been in. The marshal comes and knocks on your door and you're served with papers, suit papers that have very intensely personal allegations of you, accusing you of discrimination, sexual harassment, whatever the case may be. And then you start the discovery process, right? Where you have to turn over all your emails, your text messages. That's going to be anxiety inducing. Then you go through the deposition process where you get grilled by a lawyer all day long about all the decisions you made. So I would say that's a difficult process, just the non-monetary component and the challenge that causes. From a pure dollar standpoint, when we looked at Westlaw, right, the employment verdicts in 2022, the average verdict was 1.4 million compared to a median of 95,000. And in terms, that's sort of one component, but also the defense costs. If you're going to try a case to conclusion, it's probably going to cost you at least $150,000. And then if you lose that case, you're generally obligated to pay the plaintiff's fees as well. And just let me give you an example how that can really drive up the exposure. There's a California case, and there's a ton of them out there, but the jury awarded $27,000 in a discrimination and retaliation case. And the plaintiff attorney sought a fee petition of $1.9 million. And that was ultimately knocked down to $700,000, but that's still 25 times what the amount that the claimant was getting, right? So that's some real money in the Williams household. I would say that creates problems for employers in two ways. One, it provides an incentive for the plaintiff's bar to bring these claims because there's a financial incentive. And two, it provides an incentive to sort of litigate those cases longer, because the longer they go on, the more their fees are potentially, and the higher the reward is. To say overall, the plaintiffs win the cases that get tried, and most of them settle, but they generally win about half of them that do go to a conclusion.
Wow. Okay. That's a lot. That's a lot in many ways. Let's talk about kind of potential new exposures, current trends, and I'm going to go back to Sarah. The laws, obviously are rapidly changing around discrimination in the workforce. What do employers need to be aware of around discrimination issues?
Sure. I will say it is a really active time, Joan, in the workplace legal landscape. We are seeing a real emphasis on pay transparency and pay equity. It's a huge issue, right? Are you paying people of different genders different pay ranges, right? And if so, is there a legitimate reason for it, or is it discriminatory? We're seeing a lot of disclosure requirements on employers to disclose the pay ranges in their job postings. And it's creating a lot of buzz. We are also seeing, new classes of protected class. Obviously, the EEOC guidance I touched upon focused a lot on like gender identity, which isn't necessarily new, but certainly at a federal level, that focus is renewed. But even things like people's weight, right? Or perceived disability. You may not be disabled, but if you are perceived to have a disability by your employer, we're seeing a lot of expansion in those types of protected classes.
Okay, thank you for that. And Chris, I'm going to go back to you. So what are some examples maybe of newer exposures that you're seeing for employers?
So everybody's talking about AI at the moment, right,
Yeah.
Joan? And let me give you an example. The EOC brought a claim on behalf of an applicant who applied for a position, put in his true age, which was over 60, didn't get a call back because it went through some AI software. And when he lowered his age to below 60, all of a sudden his application got accepted and he got called in. So the EOC brought a claim. They ultimately settled that case for $365,000. New York has implemented a law basically saying if you're going to use AI software in terms of looking through applications, you have to tell employees about that. You have to disclose those results. I'd say we're closely monitoring it, but it's probably a little early to see what really the outcome is going to be of using AI overall in that context. Probably two other things.
Wait, Chris, in that example though, so the guy applied as over 60 and then he applied as under 60. So he never actually worked at the company.
No.
He just submitted 2 applications and he was awarded $365,000.
Yeah, the EOC, resolved it for $365,000.
And so are employers disclosing that AI is being used in sorting through applications? Is that something that you said New York has a new law, but what about other states?
I think they're considering it, Joan. I think it's sort of legislatures sometimes move a little slowly, right, in terms of reacting to these societal trends. So they're sort of working their way through that. And I wouldn't be surprised if you saw more similar laws like that. But again, that's something employers need to be conscientious of because it potentially creates exposure for them in the long term.
What about this? What about remote and hybrid work? Scrambling things up for employment law, Chris. What are you seeing there?
So that creates a real challenge for employers, right? As they brought people back into the office and they've tried to do that overall. Some people may be granted the ability to work from a hybrid and some people may not. And that could have potentially discriminatory impacts on the group that's allowed to work remotely and those that aren't. I would say other times you see claims by people that are asking for accommodations to work from home. For example, maybe they have some disability like anxiety or depression, and it's very difficult for those folks to come into the office. And that's a hard issue for employers to manage because you are obligated to work with the employee to consider what's a reasonable accommodation, but then everybody else that's coming into the office may perceive that as unfair. One of the things I did this morning, I think, Joan, when I was looking at the data, the claims have definitely gone up, right, since people have returned to the office. And I think that's not a surprise. There's more one-on-one interaction, more work dinners, more conferences where alcohol is served, sometimes inappropriate conduct happens. But I also think employers are maybe monitoring the employees at work a little more closely. One of the things I did this morning, I was looking at Amazon. I don't know if you've heard of a mouse jiggler, but you can buy a device that moves your mouse around So it looks like you're actually working, you know, you have Teams or a software like that on your computer. And there were 18 pages of those mouse jigglers that you can buy on Amazon. And like I think 30,000 reviews on the first half page. So a lot of people are using those. That was my conclusion. So I think if people are coming to the office more frequently, probably getting scrutinized a little closer. You may also remember at the start of the pandemic, a lot of IT workers, not a lot, but there were some that were working 2 or 3 jobs at a time, right? So I think there's more scrutiny on the employees that are coming into the office generally.
Okay, well, thank you for that. That's interesting. I don't have a mouse jiggler. So I guess things are created for all sorts of purposes. Sarah, let's talk about maybe a very sensitive subject, but I do want to bring it up because I think it's important, especially in this environment. Politics has entered the mix of what is permissible into the workplace. And so what are you seeing? What are you hearing? What advice do you have for employers about people talking about their political views in the workplace?
You are 100% right. It is a very common question this season that we are seeing. I grew up being told there are a couple things you don't talk about at the dinner table, religion and politics. But we know that when employees, watch the debate or come into the office talking about the water cooler, their weekends, it comes up. And as an employer, there are a lot of things to be aware of, right? Employers in many states may have state statutes that limit employers' ability to regulate an employee's talking about politics in the workplace, and yet you're trying to have them focus back on the work. You also see when people are talking about politics, it may start to implicate other protected classes, right? Like religion or personal beliefs about medical issues that they're feeling or dealing with. And so it is very complicated. My advice to employers is do not issue any blanket policies prohibiting this type of speech. Rather, seek out legal advice and counsel. It's a good time to take a look at your policies. It's a good time to train your managers. It's the frontline managers who hear these discussions. And if they don't know how to deal with this, then there's a lot of exposure for employers.
Yeah. Okay. Well, thank you for that. As many people know, I just want to put a little commercial in for our Citizen Travelers program here at Travelers. We encouraged all of our employees to be civic-minded and civically engaged in a nonpartisan way. And so that Citizen Travelers programming is sometimes on our webinar series. I encourage everyone to listen in. They're really well done. Okay, back to the show. So, Chris, you've spoken about rogue employees. So a rogue employee is creating liability for their employers. What do you mean by that?
Well, this
And
might be
give us an example.
PG-13 part of the presentation, sort of like behavior that happens in the workplace, right? So I'll give you a couple of examples. Somebody's rolled up in bubble wrap, driven on a forklift around, and then they have garbage dumped on them. I'd say somebody's manager charges into the bathroom stall to approach the employee. Employee is waterboarded as part of a sales training technique and told to try to make a sales as hard as they are trying to breathe in that situation. Had a claim where somebody was in a wheelchair, they poured lighter fluid around it and played Johnny Cash's Ring of Fire. So those are employees, right? When they got hired, I'm sure the employer never in a million years thought that was going to be the result of those situations and they'd end up in litigation. Those employers have policies, right, about respectful treatment in the workplace, but it just takes one person acting inappropriately, and that can create a world of headaches and litigation exposure and dollars exposure for the employers. And from us as an underwriting company, right, it's difficult to identify who those employees are that are going to be the problem long term. And you can do everything right from an employer's perspective, and you can have an employee like that that creates a real challenge for you.
Okay, sorry to hear about some of those. Those are really, really awful things to deal with. Still with you, Chris, I have a question about people returning to the office. Obviously, a lot of people, as you say, going to conferences, we're having lunches and getting back to kind of quote unquote the new normal. It's also created a number of workplace relationships that are blooming. And we've seen a lot of this. I've read recently that there's a lot of relationships. And how do how does this create an issue for employers, and how do you recommend people handling it?
Yeah, so there's some interesting stats about this, right? That was stunned by it, right? That 49% of workers had a crush on a coworker. 21% of workers went on a date with a coworker. 10% people admitted to having feelings for their boss. I was a little surprised by all of those, really. But there's really no law that prohibits workplace relationships, but it does create potential exposure three ways, Joan, for employers, right? You could have one employee pursuing a romantic relationship with another employee. It could be outside of work, could be inside of work. It could include a couple text messages, but we've seen those claims where there's multiple text messages, and one employee may perceive it as, the other party's interested, but they may really not be interested. So that can give rise to sexual harassment claims. More extreme cases, right? We've seen claims where manager requires a hug every time somebody comes into the office. Explicit pictures are shared over over iPhones and devices. Alcohol tends to exacerbate these situations, probably not a big surprise. The second situation, I think, where it creates exposure is if there's a relationship in the workplace and the parties break up and one party is not satisfied with that breakup and they continue to pursue the relationship. That can create exposure for the employer. And the third one, and this is really the most troublesome, and employers should have policies about this, prohibiting relationships between managers and subordinates. Because there's such a power imbalance, and the job assignments that might be given to that individual, that's the subordinate. We've seen claims where managers might require the subordinate to share a hotel room on a trip. We've seen trips where they dictate what the employee wears. And again, right, we're in 2024 and you still see these claims. I've been working on EPL since 96. Now I feel old, Joan, but and I thought these claims would just go away, and I've just been so wrong about that, right? And following Harvey Weinstein, we continue to see them, and I just don't think they're ever completely going to go away.
All right, thank you for that. It's unfortunate. Sarah, so all the stuff we just talked about for the last kind of half hour, if I'm a smaller employer, I may not think that I need to worry about all these things. Is that wrong? Is that right? I'm worried about the small businesses out there.
I am also worried, Joan. Unfortunately, it's wrong. There are some laws that apply to only employers who maybe have, 50 or 25 employees, but there are many laws that apply if you have one. Even if you're a single owner, right? Technically, it would apply to you. And so there's a lot of times that I'm working with a smaller client and they say, I'm small. How do they expect me to comply with all this? Unfortunately, that is not a defense. And so every size employer, I think there's a way to block and tackle some of the issues for small employers, but they certainly could do a lot by kind of getting some help on their handbooks or, issue spotting some of the big areas like your harassment policies, your training, your accommodation issues, right, are really big ones.
Okay, thank you. So let's go back to the Chevron decision, because I want to talk about how that's impacted the claims, the employment claims that you're seeing. So Sarah, you first. Let's talk about this Chevron decision and what we should expect going forward.
So I'm a total wonky legal nerd, but I know most people on this presentation are not. I think it's going to be really interesting. So there are a ton of legal challenges to a lot of the rules and regulations I talked about earlier, the Pregnancy Workers Fairness Act, the Department of Labor rule that is increasing the minimum salary requirement. The FLSA, the federal law around, wage and hour issues, doesn't set a minimum salary. The Department of Labor has imposed that. So we're seeing a lot more activity in litigation. What does that mean for single employers or potential claims? I think every time you get a claim in where it alleges some violation of one of these rulemaking that we're talking about, you need to rethink potential legal strategies and challenging the litigation in a different way. It's no longer status quo that, hey, if an agency said it, it must be true. And so I think being really creative in how you approach claims is going to be an important part of the issue in light of Chevron.
And thank you for that. How can employers keep up with all these changes? What do you suggest? Actually, Chris, let's go to you on that. How can employers keep up with that?
Yeah, so I think law firms and travelers ourselves, we have resources that we make available to employers that provide legal updates about things that are happening and things they should be aware of. We provide training to employers that they can provide to their employees online. There's news sources that are dedicated to employment compliance issues. I will say for employers, I think it's important to have a dedicated resource or personnel that's responsible for keeping track of all these issues. And the employer has an obligation to really do their due diligence, or they can end up in an employment claim that they didn't foresee.
Okay, and so Sarah, let's talk about steps that employers can take to mitigate their risk. So what do you tell your clients on strategies that could reduce workplace risk?
So I think they're one, preventative advice and counsel before you are taking an employment action against an employee. So if you're doing a reduction in force or a termination and there's any sort of protected class or accommodation request, reach out and get legal guidance. I really do believe it can really help minimize. Two, keeping abreast of the evolving issues. Maybe in addition to what Chris said, you're doing an annual review of your policies, right? That's an easy flag to say, where am I deficient? Because it's hard to keep up with all the laws. Training is super important. Training of your managers. Those, who's the employer? It's us. It's the managers. It's the people. And I don't want to simplify what I do by any means, but to quote, right, Elle Woods and Legally Blonde, happy people don't shoot their husbands. Happy employees don't sue their employers. It's about employee engagement and creating a positive culture and workplace. And I think if you focus on that, the rest will come together.
I really like that. I do. I think engagement, highly engaged employees is what you're going for. And we believe that here, obviously, at Travelers as well. So, Chris, let's go to you. What can employers do to mitigate their exposure by their employees?
Well, I'd be remiss if I didn't mention an EPL policy, right? That is a key cornerstone of the protection, because I think you can do everything right as an employer overall, and you can still face an employment claim. We talked about those rogue employees overall, and that helps. In our claim department, right? They are phenomenal at helping resolve claims. I don't know if you know this, Joan, but they send out a survey on all their closed claims, get an average score of 9 out of 10, which I think is really phenomenal in terms of how they resolve the claims and work with the client and help manage some of that anxiety and stress that's associated with them. For me, really, the big one is the workplace culture, and that I think goes along with the engagement, and having senior management really set the tone for what's acceptable in the workplace and what's not. And if something's witnessed that's not okay, then they need to take action immediately. Employers get into trouble, I think, when they don't take action and things are allowed to continue.
So what are some additional coverages then available under EPL, Chris?
So there's third-party coverage. So we talked about claims by employment applicants, former employees, but the third party would provide coverage for discrimination or sexual harassment by non-employees. So you might see some claims by somebody with a disability that can't access a retail store, and they'd bring a claim under the ADA. We've seen some claims where people put cameras in doctors' changing rooms or retail changing rooms, and those individuals, the customers, bring sexual harassment claims. Also, the latest trend is website technology. If you have a website that's not accessible to those with a visual impairment, for example, there's technology that can sort of read that text, what the picture is of. They've seen ADA claims as well. So that's one component. Wage and hour defense, there's reimbursement for defense costs if somebody brings a wage and hour claim for overtime or minimum wages. Workplace violence reimbursement coverage reimburses costs in the event of a workplace violence event, things like PR costs, security guard, counseling services for the employees. And so the last one is immigration coverage. You may recall when you started at Travelers, probably everybody here had to sign an I-9 form, just authorizing that they're legal to work in the US. The federal government can come in and audit the employer, and that coverage would help with that audit and respond to that.
Okay, so let's talk, before we get to audience questions here, why should employers of any size really have an EPL insurance policy? Why?
I'd say the state statutes, right, they vary by employer size about what employers are subject to, although Title VII applies to employers with 15 employees and Connecticut applies to 3 employees. So you can face claims by your employees, applicants, and former employees and third parties. And state statutes, right, provide different protections for we talked about hair, the political affiliation, unemployment status. Prince George's County in Maryland, your protected class based on your personal appearance. So I think it's hard for employers just to keep up with all these trends, and the backstop for that is really an EPL policy.
So we're going to take audience questions. If you have it, put it in the Q&A, and then I want to make sure we get to as many as we can. First one is going to Sarah. This is from Stephanie Quintana of Alera Group in California. How can employment liability and workers' comp be linear but not mixed? This is a really, really interesting question, and there's kind of, I'm sure, a fine line between workers' comp and employment liability. So Sarah, what is your answer on this one?
That's a great question. We see it all the time. And so where we see workers' comp is it is certainly separate from the EPL issues, but there's a lot of intersection, right? So if somebody has a workers' comp claim, they may also have potential issues around ADA or state accommodation obligations, right? If they have a restriction and they're returned to work on light duty, employers aren't always thinking about the ADA obligations they have. If somebody has a workers' comp injury, they're not always thinking about the FMLA obligations that they may have that go along with it. If somebody have a workers' comp injury and then they need to be terminated for a legitimate, non-related reason, they're not thinking about the potential retaliation claims that we see that come along with workers' comp. There are some states that prohibit employers from terminating while someone has an active workers' comp claim. And so there are a host of issues that I think sometimes they get laser focused on just the workers' comp, which is often very formulaic, and they kind of forget about the intersection of all those really important employment obligations that employers have.
Okay, thank you for that. That's really interesting topic, I think. All right, Chris, on to you. Sharon Llewellyn of Marsh McLennan in New Jersey asks us, how does EPLI address workplace violence? Very interesting question. Workplace violence, how does that address it?
Yeah, so most carriers, I think, do it via endorsement, and they reimburse the insured in the event there's a workplace violence event. That would be something like a shooting. Depending on the carrier, they may cover robbery as well in those situations. But it really just reimburses the insured for those extra costs they have. They may have some PR costs that they need to address the issue. Employers are probably fairly stressed out by the event, so it'll reimburse to bring a counseling service in to work with those employees on that issue. If there's additional security guard required because sort of the property is now accessible to the public at large, it'll pay to reimburse that all up to a certain time frame and subject to a separate limit.
Okay, thank you for that. Chris, again, Colleen Hoffman of Lockton in Washington asked, who does not need to purchase EPL? I feel like I have quite a few middle market accounts who don't.
Colleen, I would love to come to Washington and talk to your clients overall on that issue. And I'm going to maybe flip the question a little bit in terms of employers that don't need it. I'd say if you are 100% confident that you are in compliance with the law, if you are 100% comfortable that all your employees are acting appropriately in the workplace, and you have 100% faith in the jury system, those are really the only times I think you might not want to consider buying EPL. But the cost of these claims, right? We talked about the average verdict in 2022, and it can be astronomical. And in some cases, it can put an employer out of business. So I would suggest to you, Joan, everybody really needs it.
Okay, it sounds it. Chris, back to you for another one. Jennifer Hobbs Swindell of the Insurance Center of North Carolina wants to know, what is the most common mistake you see insurance professionals make in reference to this type of coverage?
Not tendering claims in a timely manner. Like, our claim department is really great at resolving claims, but if insureds sometimes forget they have the coverage, or they think, you know what, I'm going to resolve this claim myself because I think I can do that. Sometimes those things snowball. Like you mentioned, Joan, right? We handle thousands of claims a year. We're good at finding exit ramps and trying to figure out a solution to resolve those claims. And sometimes by holding on to those claims for too long, insureds miss those opportunities to get the exit ramp and get out of those situations.
Okay, thank you for that. And maybe to Sarah now. This is from Shannon Ginsburg in California, asks, what is the most common claim in EPL that you're seeing?
Great question, Shannon. For a long time, and I don't have the EEOC statistics in front of me, and Chris probably knows better than I, it was always retaliation, right? That was the real big trend, because you can do the right thing, but if an employee makes a good faith complaint, and then they're terminated, even if their complaint wasn't substantiated, we see a lot of increase in retaliation. That tends to still be a big claim that we're seeing today.
Okay, another one coming in, thank you, from Mark Skoicher. And if I mispronounce anyone's name, I apologize. Does EPL also cover negligent hiring or negligent employment claims?
Generally, the negligent hiring would be covered, but it would depend on the specific form and whose whose policy you're looking at. So I can't speak for the entire market overall.
Okay. Let's go with this one. Joey Zenglecki. An employee gets injured and the workers' compensation is paying the employee. Employee is able to do light duty work. However, job has no light duty work and insurance lets the employee go. Employee is still drawing works comp and sues employer. Is this employer breaking the EPL rules?
So I can jump in just generally from the employment law landscape. So there are going to be state laws that are going to dictate some of this. But that's when I'm talking about the ADA accommodation process coming into play. Some states have statutes specific as to light duty obligations under a workers' comp forum. But even if they don't, we need to be looking at it like we would any other employee who has a restriction because of a medical condition to see if we need to provide accommodations. And then making sure you're documenting. I wouldn't be a lawyer if I didn't tell you to document things, but making sure we're documenting the legitimate reason for separation. I say this when it comes to any medical condition, whether workers' comp related or not, the process is as important as the end result. And so it's really important for those types of employers to take a look at all those different issues before they separate employment. So the answer is you're not necessarily violating the law, but there's a lot more that needs to go into the analysis.
Okay, thank you. And then Sarah, back to you on this one, because you spoke about this earlier. A couple of questions coming in. When you say the employee has to have access to the restroom that they want or identify with, what about if that affects or bothers other employees? And how does that really work?
Such a great question. Again, that when I was talking about that, I want to be really clear. That's according to the EEOC guidance that has come out. I think I know we already are seeing that guidance being litigated, and the litigation is specifically around the transgender components of that guidance. So you're going to want to keep an eye out. There were, I believe, 18 states, Republican states, who filed a lawsuit challenging some of those components. And so we're going to have to watch that litigation play out. But generally speaking, I can say when an employee's rights are affected by another employee's protected rights, there are no bright line rules. It's really complicated.
Okay, thank you for that. Listen, the hour has flown by. Sarah and Chris, I want to thank you so much for sharing your knowledge, your expertise. These are not easy subjects to talk about, but as you know, we deal with them every day in our claim process. So very complex. Really, you broke it down for us wonderfully. So thank you for joining us. And there's a link in our survey now about today's program. Can you please, everyone who could fill that out for us? We'd love to know what you thought and what sessions you'd like to see us host here again on a Wednesday webinar. So also, if you're a podcast person, please add our podcast to your playlist. It's called the Travelers Institute Risk and Resilience Podcast. Is now available on Apple and Spotify. So subscribe today. There's a link there in the chat. Again, Travelers Risk and Resilience. We also have an exciting lineup of both live events and webinars. Next Wednesday, the 25th of September, we'll be talking about recruiting and retaining emerging talent, which I know is an ongoing challenge for many of our agent brokers out there. Then on October 2nd, we're going to kick off Cybersecurity Awareness Month by focusing on cybersecurity and what organizations can do now with evolving cyber threats that are out there. And then on October 9th, I'm going to be joined by Charles Symington of the Big I and my colleague, Sean Romallo, EVP of Distribution, for a deep dive into the latest independent insurance agents and distribution channels. And then last but not least, we're on the road this fall with the Cybersecurity Education Tour. We're now in our 9th year of doing these events in person across government experts and industry leaders. We're going to be in Arlington, Virginia next Tuesday. So if you're in Arlington, Virginia, September 24th, come join us for lunch. These are all free and open to the public. And we're going to have a wonderful discussion. Registration is open. We're dropping that in the link as well. So I really appreciate all of you joining us this fall. We had nearly 7,000 people register for today's program, which just shows that there's great interest in understanding these deep dives in insurance knowledge. And we're here to help you weed through it, sift through it, to help your clients and customers be better off. So enjoy your afternoon, everyone. Thanks for joining in, and we'll see you next week.